to talk to you about is where do we stand with the Second Amendment right now, okay? So we all know what the Supreme Court has said. In the Heller case, of which I was proud to have been a part. By the way, I've sued the District of Columbia for 4 times now, twice as a plaintiff and twice as an attorney. And we're batting 3-0 at this point, and we'll see what happens with the next case, which hopefully I can talk to you about if we have time. But in the Heller case, the Supreme Court determined that the District of Columbia residents have the right to possess functional firearms in the home for self-defense, including a handgun, okay? The McDonald case out of Chicago in 2010 determined that the Second Amendment applied to the states and specifically said that the right to keep and bear arms is a fundamental right, essential to our concept of ordered liberty. A fundamental right essential to our concept of ordered liberty. Then in the Catano case out of Massachusetts, that reversed a Massachusetts court's upholding of a ban on tasers and stun guns. And as a result, electronic weapons bans have fallen across the nation. I was proud to have sued the District of Columbia to legalize tasers and stun guns in the district and also in Baltimore County, and Howard County. And my good friend Alan Beck took up the mantle and sued pretty much everybody else that banned tasers and stun guns. And I think he's won every one of them or gotten a settlement. Okay? Now, since Heller, there had been a variety of cases penetrating through the federal courts. And I'm going to talk about a few of the cases that are pending right now in the courts of appeals. Now, these break down into several categories. The right to carry outside the home for self-defense, and to a limited extent, the definition of so-called sensitive places. We have limitations on particular weapons, such as so-called assault weapons, also cases involving switchblades, butterfly knives, nunchucks, and police-type weapons. Again, my friend Alan Beck has been involved in a number of these, a butterfly knife case in California and nunchucks in New York. And then we have firearm magazine capacity cases. We also have the right of 18 to 20-year-olds to purchase handguns. And a big issue right now is the ATF's reclassification of bump stocks as machine guns. We also have the issue of self-built firearms, which is my current case in the District of Columbia. And then we have various challenges to prohibitions on firearms possession by prohibited persons. These are as-applied challenges saying that in my particular case, yes, I had a commitment 20 years ago to a mental institution, but I'm not mentally ill now. I deserve to be able to own a firearm. And also some cases involving non-violent felons or persons who have been convicted of misdemeanors that are punishable by more than 2 years. The biggest case right now, or the biggest issue, is right to carry. I believe it's something like 44 states are either right to carry de jure or de facto, okay, meaning by law or by fact. But you have a number of states, New York, New Jersey, Maryland, Hawaii, California, I'm probably leaving out one, in which case the ability to carry is determined by the discretion of licensing officials. And the federal circuit courts, 7 of them, have decided issues on this. The First, Second, Third, and Fourth Circuits have said that to the extent there's a right to carry outside the home, We're not going to say there is one, but to the extent there is one, we can limit it to people who show a special need, okay? Then we have the Ninth Circuit, and they say, well, there's no right to carry outside the home whatsoever. Contrasting that, you have the Seventh Circuit in the Moore versus Madigan case out of Illinois, and you have the D.C. Circuit in the Palmer case, and ultimately the Wren and Grace cases that said essentially that there is a right to carry outside the home, and because of those cases, Illinois is shall issue, and the District of Columbia is now shall issue as well. And by the way, I'm a District of Columbia instructor. Those of you who live in the area who do not have a District of Columbia carry permit, get a hold of me, because there is tremendous psychic pleasure in legally carrying a gun in the District of Columbia. Currently pending at the Supreme Court is the case of New York State Rifle and Pistol Association versus Bruin. And this is a tremendously important case. It's going to be heard by the Supreme Court on November 3rd. You can listen to the argument online from the Supreme Court website, and I urge you to do so. There have been 82 amicus briefs that have been filed to date in the case, pretty much split equally between the freedom-loving people and the tyrannists. And the essential facts are that two very well-qualified gun owners were denied what's called an unrestricted pistol license in New York. Basically, to even own a pistol in the state of New York, you must have a license. And in New York City, they jump you through so many hoops, and it costs you so much money that only the wealthy basically can own a pistol. But under New York law, you have to have what they call a proper cause in order to own to carry outside the home. And New York law defines proper cause, or what is not proper cause, as a generalized desire to carry a concealed weapon to protect one's person and property. An applicant instead must demonstrate a special need for self-protection distinguishable from that of the general community or a person's engaged in the same profession, which basically means that Howard Stern and Donald Trump get carry licenses, but very few other people in New York, unless of course you bribe the unit that issues those permits. Now, the case is important not only because it will determine whether there is a right to carry outside the home, but an equally important thing that will be determined is what standard of review will the courts make in order to determine whether a law is constitutional or not. At least we're hoping we'll see that. Traditionally, courts evaluate fundamental rights cases using what are called tiers of scrutiny. The highest level of scrutiny is called strict scrutiny, and under that standard, the state must show a compelling interest in regulating the conduct and must select the least restrictive means to achieve that compelling state interest. And very few laws pass that kind of scrutiny. That tier generally applies when there's a substantial burden on a fundamental right or when there is some type of discrimination against a protected class. A lesser standard of scrutiny is called intermediate scrutiny. And there the government must show an important governmental interest, and the regulation must not, the regulation must be narrowly tailored so that it does not excessively burden the protective conduct any more than necessary to achieve that important governmental interest. And then the last tier of scrutiny is called rational basis scrutiny, and basically that applies to all other types of legislation, and basically almost all laws that are subject to rational basis scrutiny are upheld. Now, the problem that we've had in Second Amendment cases is that the courts say, well, you can still have a gun, so you're not excessively burdened by this regulation, so we're going to apply intermediate scrutiny. And this intermediate scrutiny is actually so watered down that it's indistinguishable from rational basis. And so virtually the courts that apply this, essentially they'll let any regulation pass, okay? In certain circumstances, very limited, especially in the Seventh Circuit and the D.C. Circuit, they have invalidated some restrictions. But if you go to California or you go to New York or New Jersey, they're going to let things go. So that's the Bruin case. I urge you to listen to the argument. Number of other cases that are pending, and I'll run through them real quick because my time is evaporating quickly. Duncan versus Becerra is a challenge in California to the ban on standard capacity magazines holding more than 10 rounds. It is being heard by an en banc Ninth Circuit panel. That's 11 active judges in the Ninth Circuit. And unfortunately, that panel is packed with Clinton and Obama nominees. And likely we won't have a decision until sometime in 2022. Another case in California, Miller versus Bonta, is a challenge to the California ban on assault weapons. And that case is actually stayed until the decision in Becerra. There's another case that's actually ahead of it called Rupp versus Bonta. Neither of those are likely to be decided before Duncan, and probably not before the Supreme Court's decision in Bruin, which will come sometime in 2022, probably sometime between April and June. We have Gun Owners of America versus Garland, which is a Sixth Circuit case involving bump stocks. That's being heard by an en banc court in the Sixth Circuit, and that will be packed with Republican nominees. Hopefully we get a good decision there. Laura versus Ivanchek is a Third Circuit case, challenge to the restrictions on the issuance of carry permits to persons between the ages of 18 and 21. Problem with those types of challenges is that by the time the case gets decided, the individuals have turned 21 and the case ends up getting mooted. There's another challenge in the Third Circuit, Williams versus Garland, from someone who was convicted of a misdemeanor with potential jail time in excess of 2 years. Basically, it was a second DUI case, and he's making as-applied challenge to the prohibition on having a firearm. Then there are several challenges pending to state restrictions on self-made firearms. I filed one just a few weeks ago in the District of Columbia on behalf of my good friend Dick Heller. The district is unique. The district says that we prohibit the manufacture of firearms entirely, okay? So think about that. Think about if they said you couldn't print a Bible in the District of Columbia, okay? But they say not only can you not make a firearm, you can't have precursor parts to a firearm. And in fact, they've written their laws so stupidly that the literal reading of their ghost gun law would outlaw the Glock pistols that they issue to the D.C. police. Okay? These guys don't understand what they're doing. My time is just about up, but if there's a question, I'll take one or two. And if not, thank you for listening to me. Yes, sir.
So you represented Heller, correct? Right from the beginning?
I represent Heller in this particular case.
Okay.
In the in District of Columbia versus Heller, both Dick and I were plaintiffs in that case, and an extremely capable attorney by the name of Alan Gura handled that case, took it all the way up to the Supreme Court and won.
Very cool.
Anything else? Thank you very much. One last thing. We in America have a very important right, and that is the right to keep and bear arms. You guys who live in states where you can carry firearms, either constitutional carry or with permits, if you don't have a permit, get a permit and carry your gun. Carry your gun. Your life is important. Thank you.